Rule 42, Rules of Court, Petition for Review from the Regional Trial Court to the Court of Appeals. Section 1. How appeal taken. Time for filing. A party desiring to appeal from a decision of the Regional Trial Court rendered in the exercise of its appellate jurisdiction may file a verified petition for review with the Court of Appeals, paying at the same time to the clerk of said court the corresponding docket and other lawful fees, depositing the amount of 500 pesos for costs, and furnishing the regional trial court and the adverse party with a copy of the petition. The petition shall be filed and served within 15 days from notice of the decision sought to be reviewed or of the denial of the petitioner's motion for new trial or reconsideration filed in due time after judgment. Upon proper motion and the payment of the full amount of the docket and other lawful fees, and the deposit for costs before the expiration of the reglementary period, the Court of Appeals may grant an additional period of 15 days only within which to file the petition for review. No further extension shall be granted except for the most compelling reason and in no case to exceed 15 days. Section 2. Form and Contents. The petition shall be filed in 7 legible copies, with the original copy intended for the court being indicated as such by the petitioner, and shall a. state the full names of the parties to the case without impleading the lower courts or judges thereof, either as petitioners or respondents. B. Indicate the specific material dates showing that it was filed on time. C. Set forth concisely a statement of the matters involved, the issues raised, the specification of errors of fact or law, or both, allegedly committed by the regional trial court, and the reasons or arguments relied upon for the allowance of the appeal. D. Be accompanied by clearly legible duplicate originals or true copies of the judgment or final orders of both lower courts, certified correct by the clerk of court of the regional trial court. The requisite number of plain copies thereof and of the pleadings and other material portions of the record as would support the allegations of the petition. The petitioner shall also submit together with the petition of certification under oath that he has not therefore commenced any other action involving the same issues in the Supreme Court, the Court of Appeals, or different divisions thereof, or any other tribunal or agency. If there is such other action or proceeding, he must state the status of the same, and if he should thereafter learn that a similar action or proceeding has been filed or is pending before the Supreme Court, the Court of Appeals, or a different divisions thereof, or any other tribunal or agency, he undertakes to promptly inform the aforesaid courts and the other tribunal or agency thereof within 5 days therefrom. Section 3. Effect of failure to comply with requirements. The failure of the petitioner to comply with any of the foregoing requirements regarding the payment of the docket and other lawful fees, the deposit for costs, proof of service of the petition, and the contents of and the documents which should accompany the petition shall be sufficient ground for the dismissal thereof. Section 4. Action on the petition. The Court of Appeals may require the respondent to file comment on the petition, not a motion to dismiss, within 10 days from notice, or dismiss the petition if it finds the same to be patently without merit, prosecuted manifestly for delay, or that the question raised therein are too unsubstantial to require consideration. Section 5. Contents of comments. The comments of the respondent shall be filed in 7 legible copies, accompanied by certified true copies of such material portions of the record referred to therein, together with other supporting papers, and shall a. state whether or not he accepts the statement as matters involved in the petition. B. Point out such insufficiencies or inaccuracies as he believes exist in petitioner's statement of matters involved but without repetition. And C. State the reasons why the petition should not be given due course. A copy thereof shall be served on the petitioner. Section 6. Due course. If upon the filing of the comment or such other pleadings as the court may allow or require, or after the expiration of the period for the filing thereof, without such comment or pleading having been submitted, the Court of Appeals finds prima facie that the lower court has committed an error of fact or law that will warrant the reversal or modification of the appealed decision. It may accordingly give due course to the petition. Section 7. Elevation of record. Whenever the Court of Appeals deems it necessary, it may order the clerk of court of the regional trial court to elevate the original record of the case, including the oral and documentary evidence within 15 days from notice. Section 8. Perfection of appeal, effect thereof. A. Upon the timely filing of the petition for review and the payment of the corresponding docket and other lawful fees, the appeal is deemed perfected as to the petitioner. The regional trial court loses jurisdiction over the case upon the perfection of the appeals filed in due time and the expiration of the time to appeal of the other parties. However, before the Court of Appeals give due course to the petition, the regional trial court may issue orders for the protection and preservation of the rights of the parties which do not involve any matter litigated by the appeal, approve compromises, permit appeals of indigent litigants, order execution pending appeal in accordance with Section 2 of Rule 39, and allow withdrawal of the appeal. B. Except in civil cases decided under the rules on summary procedure, the appeal shall stay the judgment or final order unless the Court of Appeals, the law, or these rules shall provide otherwise. Section 9. Submission for decision. If the petition is given due course, the Court of Appeals may set the case for oral argument or require the parties to submit memoranda within a period of 15 days from notice. The case shall be deemed submitted for decision upon the filing of the last pleading or memorandum required by these rules or by the court itself. Rule 43. Appeals from the Court of Tax Appeals and quasi-judicial agencies to the Court of Appeals. Section 1. Scope. This rule shall apply to appeals from judgment or final orders of the Court of Tax Appeals and from awards, judgment, final orders, or resolution of or authorized by any quasi-judicial agency in the exercise of its quasi-judicial functions. Among these agencies are the Civil Service Commission, Central Board of Assessment Appeals, Securities and Exchange Commission, Office of the President, Land Registration Authority, Social Security Commission, Civil Aeronautics Board, Bureau of Patents, Trademarks and Technology Transfer, National Electrification Administration, Energy Regulatory Board, National Telecommunication Commission, Department of Agrarian Reform under the Public Act No. 6657, Government Service Insurance System, Employees Compensation Commission, Agricultural Inventions Board, Insurance Commission, Philippine Atomic Energy Commission, Board of Investment, Construction Industry Arbitration Commission, and voluntary arbitrators authorized by law. Section 2. Cases not covered. This rule shall not apply to judgment or final orders issued under the Labor Code of the Philippines. Again, cases not covered. This rule shall not apply to judgment or final orders issued under the Labor Code of the Philippines. Rule 43, Section 2. Please remember. Section 3, where to appeal. An appeal under this rule may be taken to the Court of Appeals within the period and in the manner herein provided, whether the appeal involves questions of fact, of law, or mixed questions of law or fact. Section 4, period of appeal. The appeal shall be taken within 15 days from notice of the award, judgment, final order or resolution, or from the date of its last publication, if publication is required by law for its effectivity, or if the denial of the petitioner's motion for new trial or reconsiderations duly filed in accordance with the governing law of the court or agency ACO. Only one motion for reconsideration shall be allowed. Upon proper motion and the payment of the full amount of the docket fee before the expiration of the reglementary period of 15 days, only within which upon proper motion and the payment of the full amount of the docket fee before the expiration of reglementary period, the Court of Appeals may grant an additional period of 15 days only within which to file the petition for review. No further extension shall be granted except for the most compelling reason and in no case to exceed 15 days. Section 5. How appeal taken. Appeal shall be taken by filing of verified petition for review in 7 legible copies with the Court of Appeals, with proof of service of a copy thereof on the adverse party and on the court or agency ACO. The original copy of the petition intended for the Court of Appeals shall be indicated as such by the petitioner. Upon the filing of the petition, the petitioner shall pay to the clerk of court of the Court of Appeals the docketing and other lawful fees and deposits of sum of 500 pesos for costs. Exemption from payment of docketing and other lawful fees and the deposit for costs may be granted by the Court of Appeals upon verified motion setting forth a valid grounds thereof. Therefore, if the Court of Appeals denies the motion, the petitioner shall pay the docketing and other lawful fees and deposit for costs within 15 days from notice of the denial. Section 6. Contents of the petition. The petition for review shall A. State the full names of the parties to the case without impleading the court or agencies either as petitioners or respondents. B. Contain a concise statement of the facts and issues involved and the grounds relied upon for the review. C. Accompanied by a clearly legible duplicate original or a certified true copy of the award, judgment, final order, or resolution appealed from, together with the certified true copies of such material portion of the record referred to therein and other supporting papers. And D. Contain a sworn certification against forum shopping as provided in the last paragraph of Section 2, Rule 42. The petition shall state the specific material dates showing that it was filed within the period fixed herein. Section 7. Effect of failure to comply with requirements. The failure of the petitioner to comply with any of the foregoing requirements regarding the payment of the docket and other lawful fees, the deposit for costs, proof of service of the petition, and the contents of and the documents which should accompany the petition shall be sufficient ground for the dismissal thereof. Section 8. action on the petition. The Court of Appeals may require the respondent to file a comment on the petition, not a motion to dismiss, within 10 days from notice, or dismiss the petition if it finds to be patently without merit, prosecuted manifestly for delay, or that the question raised therein are too unsubstantial to require consideration. Section 9. Contents of comments. The comments shall be filed within 10 days from notice in 7 legible copies and accompanied by clearly legible certified true copies of such material portions of the record referred to therein, together with other supporting papers. The comments shall A. Point out the insufficiencies or inaccuracies in petitioner's statement of facts and issues, and B. State the reason why the petition should be denied or dismissed. A copy thereof shall be served on the petitioner, and proof of such service shall be filed with the Court of Appeals. Section 10. Due course. If upon the filing of the comment or such other pleadings or document as may be required or allowed by the Court of Appeals, or upon the expiration of the period for the filing thereof, and on the basis of the petition or the records of the Court of Appeals find prima facie that the court or agency concerned has committed errors of fact or law that would warrant reversal or modification of the award, judgment, final order, or modification of the award, judgment, final order, or resolution sought to be reviewed, it may give due course to the petition; otherwise, it shall dismiss the same. The findings of the fact of the court or agency concerned, when supported by substantial evidence, shall be binding on the Court of Appeals. Section 11. Transmittal of record. Within 15 days from notice that the petition has been given due course, the Court of Appeals may require the court or agency concerned to transmit the original or eligible certified true copy of the entire record of the proceeding under review. The record to be transmitted may be abridged by agreement of all parties to the proceeding. The Court of Appeals may require or permit subsequent correction of or addition to the record. Section 12. Effect of appeal. The appeal shall not stay the award, judgment, final order, or resolution sought to be reviewed unless the Court of Appeals shall direct otherwise upon such terms as it may deem just. Section 13. Submission for decision. If the petition is given due course, the Court of Appeals may set the case for oral argument or require the parties to submit memoranda within a period of 15 days from notice. The case shall be deemed submitted for decision upon the filing of the last pleading or memorandum required by these rules or by the Court of Appeals.